Get up. Smile. Smile kidogo. Smile pia. Kote. Hata dentist waliangaliangi. Nilikuwa naeleza whole motive. Whole motive to spread. Yote wamepewa pesa.
Let me just admit everybody who was online. I think I've admitted everybody. Unless there's somebody who is not. There is one.
A step aside from the convention, we have a convention for the ODPP 2025. But because of the 24-hour rule in the Constitution, I had to come so that plea is taken for the and get back to the convention.
Okay, fine. Thank you for that. And good afternoon, councils in. Okay. Rabi, I have the plea with me. So, okay, fine. So we have, is it Bharat Ramji? Yes. Ashwin Ramji. And then we have Harish Ramji. Which language? Okay, fine, go ahead.
Okay, I will read the charges. Just listen carefully. Count number 1 is conspiracy to defraud. Contrary to Section 317 of the Penal Code, Republic of Kenya, jointly with others not before court, with intent to defraud National Social Security Fund of a parcel of land number, LR number 11895/50.043 hectares located within Mavoko municipality, valued approximately 350 million, Social Security Fund, a fact you knew to be false. Harish Ramji Manji, true or not true?
Not true.
Ashwin.
Let's be coherent because there is Council HS on his feet. Council Level. Council Chase and Council Ndegwa, you're for all the accused persons.
Yes, we appear jointly for all the accused persons, together with the learned defendant, Mr. Ndegwa.
So A1, A2, and A3. A3. You're two councils or three?
Three.
The third council?
Me.
A2, A3.
Yes.
Okay. Okay, fine. So we can go ahead.
I was waiting for the reading of the first charge for us to raise this objection on the entire plea. We object that the plea should not be read and taken for the following reasons, Your Honor. That this matter is before your brother, Honorable Ehubi, and it appears as E568 of 2024. E568. E568 of 2024. For Mr. Ehubi, and it is word for word, including the punctuations. For that reason, we object. The matter is coming up for mention before Honorable Ehubi on 8th. The matter came up on mention last on 8th of September 2025. And I think it has the next mention on Monday the 14th of December. And the purpose of the mention before Honorable Ehubi is to confirm the status of the Court of Appeal. There is a Court of Appeal decision staying the arrest, investigation, and prosecution of the accused persons in civil application number 388 of 2024, dated 20th September 2024. It's by learned judges of appeal Lesit, Mativo, and Gashoka. The Court of Appeal registered this morning asking them to formally certify that ruling and share with the court directly. The ODPP, who is party to the proceedings before the Court of Appeal, and the DCI. Our clients were arrested at about 11 today morning, and they have been arraigned with unprecedented efficiency. And for the reason that the facts in this charge sheet are the same, relate to the same subject matter, the same instruments, the same persons, and that the Court of Appeal has stayed the same, is sufficient reasons, Your Honor, to, in the very least, even before the plea, verify our arguments, because and the files are in the custody of the judiciary, and we can be back once the facts have been verified.
Who has referred to. I fully associate myself with the submission that he has made, but add that, Your Honor, that this is an abuse of your process by the office of the ODPP and the office of the Inspector General. Your Honor, it is true what counsel has submitted on that the charge sheet is a replica of what is pending before your brother. Equally well, it's a replica of the facts that were pleaded before the Court of Appeal, as elucidated by my learned friend, Mr. Secha. Number two, Your Honor, the subjects before you were already admitted on bail by your brother. And therefore, they have been enjoying that right under Article 49. And even their arrest was procured, their arrest has gone against the whole hallmark of a bail, or the reason of granting bail. The individuals before Your Honor ought not to have been arrested in the first instance. Granted the fact that the Court of Competent Jurisdiction has admitted them to bail, face of record, that the office of the DCI can move to obliterate, ignore, assume, disrespect the authority of your court. It is your court that has granted these individuals bail because they were granted by a court of competent and equal concurrent jurisdiction. You know, my appeal is that this plea be deferred and the file be forwarded to your brother, that for consideration by your brother. And the matter is coming up on Monday, Your Honor. Is it possible in criminal practice, Your Honor, that two courts of equal and concurrent jurisdiction can be seized of the same matter? And the subsequent arraignment before you is meant to achieve ulterior motives other than the ends of justice. And the office of the DCI is aware that the matter is coming up on Monday. They have been actively participating in the proceedings. We have been updating them on day-to-day basis. What was the urgency, Your Honor, if the urgency was not meant to abuse the process, short-circuit the process, and assume the scenario where your court is exercising jurisdiction over another court. If a court of competent jurisdiction admitted them to bail and deferred the plea, how then will your court move to admit this charge sheet of the same particulars, the same provisions of the law, when your brother is seized of that matter? Where shall we strike the balance? To whom shall the subject before you submit before? Will they submit before you or submit before your brother? And in whose benefit is that quagmire? In whose benefit is the legal quagmire? If it is not in the benefit of the accused person, Your Honor. We submit that, Your Honor, that you defer this plea, order that the subject appear before your brother on Monday, so that these arguments can be urged before your brother, and the implication of the judgment of the Court of Appeal can then be squared out. Its implication can then be determined. Your Honor, we urge you to decline the invitation to appeal fair trial before your court. Article 50, Your Honor, is paramount, as read together in Article 25, that they require a fair trial. Can fair trial be competent jurisdiction of equal and competent jurisdiction? I rest my case, Your Honor.
From my two colleagues, Mr. Chesa and Mr. Ndegwa, the petition, I would urge the Honorable Court to analyze the facts before you. We have supplied the ruling from the Court of Appeal, but the same is not certified, but it's a Court of Appeal ruling, and we are humbly requesting that this plea be deferred even to Monday, 8th of December, so that the court will be seized with relevant documents and both sides will deliberate on the issue of sub judice with a free bond, because bail cannot be issued twice. And the matter be placed before the trial court to avoid this confusion. I invite the court to look at the facts that the accused were arrested at 11 today, 11 in the morning. This is around 3:30 p.m. The processing and coming all the way to Milimani on a graduation day in various universities where there's traffic jam, and we're in court now. That is malicious prosecution itself. There's no other explanation beyond that. Kindly, Your Honor, where you are, this is a court of justice, it's a court of law and procedure. Accord our clients, the three accused persons, with free bail, and as counsels, Mr. Chesa, Mr. Orenge, and Mr. Ndegwa, we undertake to bring them on Monday morning. Before the court, you will direct. I rest my case.
We have heard the sentiments of my learned colleagues, and we understand them to be making a plea for deferment of the charges. And if we understand them correctly, they have presented two grounds. Number one is that this matter before you is already pending before your learned brother, Honorable Ehubi, in criminal case E568 of 2024. They have informed you, Your Honor, what the three counsel have not pointed out to you, and we have no objection to them referring into the uncertified copy of the Court of Appeal ruling, is they have not pointed to you any paragraph in that ruling which makes reference to criminal case E635 of 2025. The criminal case E635 of 2025 before this honorable court has been registered today. Is that the criminal cases before you and before your brother, Honorable Ehubi, are, as a matter of logic, different. The case before you is E635 of 2025. The case before your brother is E568 of 2024. Two different cases. Number two, this cannot arise in criminal law. The closest of the applicability of that doctrine would be either the doctrine of outrefoi acquit or outrefoi convict.
Your Honor, objection, Your Honor. Objection, Your Honor. Counsel is misleading the facts. We have not submitted on the question of sub judice. Let him restrict himself the response on the submission we have done. He's raising new issues, Your Honor.
Your about sub judice. And that should not be my problem because Mr. Orenge is on record. So Mr. Ndego, if he was not listening, he cannot accuse me of referring to what was not said.
Your Honor, I'm in court with Mr. Orenge, in fact closer to his mouth than Mr. Owiti, and I have not heard him submit on sub judice, and that the learned prosecutor is on a fishing expedition to bring in academic matters in a very straightforward matter. And I the argument.
In the record, I know my learned colleagues have a way of just going around. The court will just read its record through at the end. Mr. Orenge mentioned sub judice. And Mr. Orenge is in court. Why is Mr. Echesa the one refusing that Mr. Orenge?
This afternoon, this court rules as follows. Number one, I'll give a personal bond of 200,000 plus each a contact person for each accused person. Number two, both parties, that is the defense and the prosecution, to avail the charge sheet mentioned and the citations in the case before my brother, Honorable Ben Mark, on Monday. Number three, that the Court of Appeal ruling that you both mentioned, citing the stay orders, also be availed before this court. And lastly, that this matter will be mentioned before this court on Monday, the 8th day of December 2025, before my court. These are the orders of the court, read at 16:10 East African time, this 5th day of December 2025.
The staff wasn't in today. I was even able to get the deputy registrar, so that then Monday, today.
No, today we are all working. It's the ODPP who are not there. We are all working.
At the Court of Appeal, there was skeleton staff today. We did the writings. And Monday being a working day, if you have the courtesy or if you have the leniency of allowing us on Monday, Tuesday morning we'll be here because we can sleep at the Court of Appeal on Monday morning.
I didn't want... Sorry. Yes, what do you want to say, Councillor Wite?
Your Honor, we don't oppose the production of the Court of Appeal ruling that they have as it is. So we don't have to wait for the Court of Appeal. We would like to appear before you like they had proposed earlier on Monday.
When we can do it at 3 p.m. You said two non-persons or one person, the personal bond.
That a personal bond of 200,000 plus each a contact person for